Mr. Roy for his opening statement.
I want to thank the gentleman from California and my co-chairman on this hearing. It's an important hearing. I thank him for his work on this issue as well as his legislation addressing the matter. And I'd like to welcome the guests who are joining us here today. Appreciate your time, obviously, particularly you, Mr. Speaker, and your great service to this country, and great to have your expertise here. We thank you. And I also want to give a shout out to Cindy Romero. I met Ms. Romero last August in Aurora, Colorado, and I appreciate what she's going to be here to testify about today and her great service. So with that, I would like to take a slightly different angle as the chairman of the subcommittee on the Constitution than the direction that my friend from California took, because I want to emphasize the judicial overreach we've witnessed over the last 2 months and nationwide injunctions more broadly that are undermining the constitutional structure our founders so wisely envisioned. The nature of the executive branch was a primary point of contention at the Constitutional Convention. Some delegates favored a plural executive, thinking that this arrangement would better preserve liberty. But they were wrong, and our founders wisely resisted their calls. Instead, the Constitution lodges the executive power in a single president of the United States. Alexander Hamilton offered the classic defense of this arrangement in Federalist 70, emphasizing that a vigorous and energetic executive is necessary to defend our liberty from foreign threats. Hamilton rightly argued that unity in the executive was the essential ingredient in this formula. Only a single executive could act with the decision, activity, secrecy, and dispatch necessary to adequately carry out the office. And on a note, I have introduced legislation in the past, it's called the Article 1 Act, to try to cabin in the executive branch when it's not necessarily working directly with Congress, and I'm happy to work with my colleagues on the other side of the aisle on these concepts when we have these lingering emergencies, in many cases these national emergencies that date back to the 1970s. There are times for the Congress and for the legislative branch to assert itself, but the president's authority is at its zenith when we're talking about his actions as commander-in-chief. Injunctions and temporary restraining orders halting presidential actions nationwide threaten the key feature of our constitutional architecture, undermining the core premise of unity in the executive branch, the unitary executive, as we refer to it. Even the most strident proponents of a plural executive at the Constitutional Convention advocated for an executive council of 3, maybe 5 members. Today, in practice, we are governed by an executive council of 678. The nationally elected president and 677 district court judges, each of whom retains a functional veto over executive actions through their power to issue nationwide injunctions. Scholars have long understood that a hostile judiciary or even a single hostile judge could abuse its power to issue nationwide injunctions to infringe upon the lawful authority of the President of the United States. Now, that's not a partisan point. I've got numerous examples of our colleagues on the other side of the aisle who have raised these concerns. The Biden administration's Solicitor General, Elizabeth Prelogar, told the Supreme Court as recently as 2024 that, quote, a court of equity may grant relief only to the parties before it. The district court violated that principle by issuing a nationwide injunction, ... In 2022, Solicitor General Prelogar asked the Supreme Court to address nationwide injunctions as permissible relief in the United States versus Texas, arguing that district courts normally, quote, should only provide relief for the benefit of the prevailing challenger. What happened there was our Democratic colleagues started realizing that when Republicans went to district courts to get injunctions against their president, that suddenly they didn't like it so much. So they were raising concerns. Justice Elena Kagan spoke out against nationwide injunctions by a single district judge in 22, quote, the ability of a single judge to stop implementation of a policy across the country. She stated, in the Trump years, people used to go to the Northern District of California, and in the Biden years, they go to Texas. Just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process. Former United States Rep. Mondaire Jones introduced the Injunction Reform Act in 2022. I could go through the quotes that he offered, but I won't. I can offer those for the record without objection. In a letter to William Torrance dated June 11, 1815, Thomas Jefferson explained who decides constitutional questions. Certainly there is not a word in the Constitution which has given judges that power, authority to decide on the constitutionality of a law more than to the executive or legislative branches, meaning we all have an obligation and a role to do that. Questions of property, of character, and of crime being ascribed to the judges through a definite course of legal proceedings, laws involving such questions belong, of course, to them in the judiciary. And as they decide on them, ultimately and without appeal, they, of course, decide for themselves the constitutional validity of the law. In other words, our founders never intended the federal courts to have the ability to unilaterally decide constitutional questions, as these judges are unelected and were never given the power to legislate from the bench. Treating the courts as the final authority on public policy, grants them more power than even Madison's rejected Council of Revision proposal at the Constitutional Convention. Indeed, it happened regularly during the first Trump administration, as we pointed out. Now in the second Trump administration, it is on steroids. As of last week, district courts had issued no fewer than 17 nationwide injunctions against administrative actions, with scores more temporary restraining orders, or TROs as we call them, as barring the president from enacting the agenda upon which he was elected. Alexander Hamilton wrote in Federalist 78 that even the Supreme Court would wield neither force nor will over politics, indicating he never envisioned the judiciary having the final say on every political decision or action. Now these injunctions and TROs have even infringed upon what the Supreme Court has described as conclusive and preclusive presidential powers, including core presidential authorities to conduct foreign affairs and repel invasions. Now, I have got numerous examples of what we've been dealing with. Just so people know, this is a 56-page summary that I've got of the 158, it might be 159 now, because we're having to track them on a daily basis, lawsuits against the administration and against the president for carrying out the agenda upon which he was elected. 17 injunctions, I think there are a great number more TROs, and the cases we're talking about, without going through all of them, nationwide TRO enjoining the Trump administration from freezing foreign assistance funding, enforcement order requiring the administration to pay approximately $2 billion within 36 hours. That's a judge singularly acting against the president's actions. Another one, provisionally certifying a class and enjoining the Trump administration from deporting members of a foreign terrorist organization. A nationwide injunction enjoining the Trump administration from pausing, terminating, or amending any equity-related grants or contracts, DEI. A nationwide injunction enjoining the Trump administration from prohibiting federal funds from being spent to promote gender ideology. A nationwide TRO enjoining the Trump administration from prohibiting biological men from being housed in women's prisons. 2 injunctions regarding the administration for implementing an executive order considering transgender individuals in the military, birthright citizenship, issue after issue after issue that the administration is trying to act on according to the campaign upon which he ran. One in particular has earned the scrutiny it has received. Just 2 weeks ago, Judge Boasberg of the District Court of the District of Columbia ordered the administration to stop the deportation of members of Tren de Aragua, a violent Venezuelan gang that has terrorized cities and towns across the country. At this table, in this room, we heard testimony from Alexis Nungare, whose daughter Jocelyn was murdered by TDA in the suburbs of Houston. Right here, we heard her powerful testimony about what that gang has done to this country. We're going to hear from Ms. Romero today about what that gang did to her community in Aurora, Colorado. And here we have a single district judge who's asserting jurisdiction from the District of Columbia to tell the President of the United States that he cannot deport members of the violent TDA gang out of this country to keep our streets safe. That is not what is supposed to occur. Today's hearing, what we'll learn from constitutional scholars and real Americans about what is wrong with the current system, is a good start. We should carefully study whether Congress should push back against judicial overreach using its constitutional power to structure and fund the courts. Our Constitution did not create a plural executive or judicial tyranny. Today, we're far too close to both. With that, I yield back.
The gentleman yields back. We now recognize